Hello, welcome. It's Friday afternoon, and you are present with Courtside with Lawman and
Carmen B. I'm here. I'm here. I'm just audio, not video.
so Carmen is joining us audio tonight. So I'll be sitting here manning the ship, so to speak, but she is a full-fledged participant this evening.
That
Now,
is the plan. We again appreciate everyone for taking time out of their day to watch the show. We would remind you that the show is informational and educational. We certainly encourage you making comments in the chat or even calling in. And you can call in at 916-443-5288. Again, that number 916-443-5288.
all right. And I think she said, of course, we will talk about issues that you can bring up to us, either through chat, call us, or something. So, whoa, I'm getting hits on the web. Shoot. Okay, I'm still there, but I think I'm stuck. I think I'm froze. Yeah, I'm froze. God damn it.
Do you want to restart it? Technical difficulties.
Here we go. All right, here we go. All right, it's back. All right, I think we just had a hit or something. There was police going by and things like that, so it may have been something weird happening. But I am back again. Tonight, we have entitled this show tonight, Attorney-Client Relationship. And so attorney-client relationships. Hold on, let me there's Carmen. Although I'm not going to hold the phone, okay? But we've entitled it Attorney-Client Relationships. And what that means tonight is this. We'd like to talk about and bring the subject up about lawyers and their role in the criminal justice system. And how do they play their role in the criminal justice system? You know, what do they do? What you should know about picking a lawyer, choosing a lawyer, how to feel comfortable with a lawyer, and the things that a lawyer should do. So, to start off with, so Carm, anything unusual happened this week for you?
I don't know if I would say unusual, but events happen, life happens, and sometimes these things take you away from your main focus. So just dealing with one of those types of issues right now, trying to get some things cleared up with family.
Yeah. And
your family. Can't live without them.
That's true. I'm going to try to throw some more light on the issue. There we go. All right. And that is true. And I would say, I feel very blessed just to be around and be alive and stuff this week. One of the things that we got to talk about, and that just has popped up as of yesterday, pretty much, is that there's been a COVID outbreak at the county jail.
Oh,
yes.
I was unaware of that because I'm not there.
Yes. I think it was in the news. I mean, yesterday we knew because I was trying to visit a few people and couldn't go up, into the pod. So I don't know how extensive it really is now, but let's say they've been closing down a lot of the pods and stuff like that, trying to get control of it. And then that means that individuals who are exposed must be quarantined for a number of days. So we're going to probably be missing some court appearance, clients missing court appearances and things like that. But
I have had that happen and not so much as that they specifically had been exposed, but instances where clients were transferred from the downtown facility out to the Oak Grove facility, and then they automatically quarantine them.
Yep.
I believe they're doing a 10-day time period,
Yep.
10 to 14 days, I guess, depending on if they exhibit any symptoms.
Yeah.
That can be somewhat problematic, though, because they haven't been exposed, but they're just
Got to be quarantined. Yeah.
Coming from one location to another location.
Yep. And I'll tell you, Elk Grove has the breakout too. It's hit Elk Grove too.
I do know that there were over a period of about 2.5 weeks, I had one client that I tried to visit multiple times, and both times I was told because he was on quarantine, and not necessarily that client was sick, but if someone in the
they stop visits for family and things like that, So, but that's going on down at the county. I'm hoping it'll ease up a little bit later because we're talking about opening up courts and doing trials and things like that. So it's going to be important that reopens and that we can do trials again. But tonight we're going to talk about attorney clients. So
clients.
Yes.
What are attorney clients?
Well, attorney and clients are individuals who will work together in order to, find their way through the criminal justice system, to tell you the truth. But to start off with, we probably got to talk about how does one become the attorney in the. So I'll start off by saying, if you did not know, to become a lawyer has become far easier nowadays. When I was signed up to be a lawyer, usually you had to have your 4-year degree. You apply to a law school, you get accepted, you will go through 3 or 4 years of law school, and then they will give you the bar exam, which is done twice a year. If you pass the bar exam, nobody cares what score you had, you became a lawyer and you received your number. And from that moment on, you are known by that number. Criminal lawyers have to use their bar number far more probably than civil lawyers, because of whenever we visit somewhere or go somewhere or do something like that, we got to pull our bar card out usually and show people.
I would disagree that you become known by that number. I don't think that anyone actually, I know my number. I don't think that anyone else actually memorizes that number. They certainly take it down and they enter it into the system when you visit the jail. But, it is rare, if ever, that you have to show it in court. In fact, Mr. Lawman, I don't know if you recall, this was some years ago. There was a gentleman who had appeared in court on a case, and I think they discovered that either he was not an attorney, or he had been disbarred and was still
trying to practice.
So it's not something that the courts themselves, meaning the judges or the clerk staff, asked to see on a regular basis. But when you are doing jail visits, it is more so the sheriff that will ask the deputies that are working that will ask to see your bar card. Or if you're visiting a client who is in prison, you will have to display usually your bar card and your identification. But Lawman and I have been practicing so long in Sacramento County that the majority of the deputies who are regulars and who've been deputies, as long as our careers have been coming along, don't usually require that because they see us on a regular basis at the jail, courthouse, or at the other facilities that we have to visit. They recognize us.
Okay. Now, because not because I like to be an antagonist, but I am going to disagree with Carmen. And I will explain my experience with my bar number. Okay. First of all, when I was a young lawyer with dreads and I would go out of county and they did not know me, they would ask for my bar card and they would stop me before I go over what's called the bar, which is the delineation between the court staff as well as the lawyers' tables and the audience. They call that the bar. So when I would walk past the bar and stuff, if a bailiff didn't know me, they'd come over and they would ask for such a thing. Well, do you have your bar card? Like it was the regular thing to do. Now, the ones down here at the county jail, because I was lucky enough to get a bar number of 164164, is that they do memorize my bar card and they brag about knowing my bar card number. Because other lawyers would be like, oh, yeah, my number is great. And they're like, yeah, but Mr. Staten is 164. I was told stories about this.
Well, that certainly, I wouldn't even say that you're controverting what I said. You're expressing the experience that you've had and having that unique number. That certainly makes that experience relevant. And I would note that as an African-American woman, I can't speak to what you have experienced as an African-American man. And so
with dreads.
I can imagine, yes, when you have dreads, I can't imagine, especially when appearing out of county,
right.
That there would be people who would just assume that you couldn't possibly be an attorney, which is unfortunate.
True, but somebody's got to be a trendsetter, right? I mean, somebody's got to break the bar, right? To me, it didn't hurt me. It doesn't bother me. I mean, I knew they're asking because they don't know who I am. They've never seen me before, and it's terrible because they make the assumption that I'm not supposed to be there. Like I just would walk up to the tables and stuff,
But let me say this, unless there were other attorneys, I have to imagine, who were appearing that they didn't know as well. Did they give them that same treatment?
I don't know. See, that I would not know because,
in circumstances and situations like that, I watch to see.
Well, sure.
Because I recall one time when there was a deputy at the jail who was insistent that that I show my bar card and my driver's license, and I'm absolutely fine doing that. But now I'm going to watch every other attorney that comes in here after me, and you better be asking them to produce both of those same documents.
Right.
And if you're not, you better explain to me what the difference is.
Well, now the branch will take them and they hold them because they give you a badge. So downtown, they take them. They can, and they'll punch your name up. At least ones who don't know you. Ones who see you every day, they'll give you your license right back if you try to give them that. But they might not memorize your bar number like me. So, but they do have to put that in the system in order to justify our visits. And I'll tell you,
and to document who's visiting.
Yes.
What professional visits the clients are having.
And I'll tell you what happens. Sometimes you can be signed in down below and you go up to try to visit your client and they tell you, well, we don't have you in the system. And so, you'll go all the way back down and say they don't have me in the system. Let me see. And I forgot to push this button, fix it. And you go back up and you do it.
Or the worst, you go up to do your professional legal visit and they're like, oh, I have you signed in, but it's for a social visit. Like, no social visits.
That's right.
Professional visits. And then you have to go back down and have them change the classification of the visit in the computer system.
Right. And so we work, that is how we are able to move around to jails and courts and facilities and things like that. As a lawyer, your bar card is your ID pretty much. And that's what you're known by. That's the number you have for the rest of your life. It's like a social security number in similar ways. But
is it like an X-reference number?
Could be. Is, yes. And which means that if the bar number is 6 digits, you can tell how many lawyers have been practicing after you. Now, they're all at 6 digits now because I think we're up to, I'm 164. I think we are up to like 38, what would be 38 or 380,000. So there's been over 120,000 lawyers who have entered the bar since I started. So it doesn't keep track of who's leaving. So we don't know how many lawyers at any one time, but we probably could, you can have that information, but it just gives you an idea. If you see a low bar number and starts with 1, that the person is much more experienced than the ones that start with 2 and definitely the ones that start with 3. So you can tell by the bar number how experienced your lawyer is. And one other, and you should do that. I mean, now we're on to that attorney-client relationship. Look, this relationship is special. So I'm going to talk about the privileges involved. But we also got to,
I'm gonna modify that slightly. You said you can tell how experienced they are. That is dependent. There may be someone who has been practicing for 20 years, but the first 15 years of that may have been civil. And
True.
They may have just moved into doing criminal the last 5 years. So when you look them up and you see, oh, they've been licensed for 20 years, you may erroneously believe that they have been practicing criminal law for 20 years. And that may not be the case. They may have been practicing law, but not necessarily criminal law.
Now,
also, sometimes there are people who pass the bar and then decide for whatever reason, and then they are issued their bar number by the California State Bar, and they decide that they don't want to practice law. They want to do something else. They want to work as a lobbyist.
Do contract work or something like that, yeah.
Yes, and they do something else for a long time period before deciding that they want to put their hat in the ring for criminal law. So don't just look at how long someone has been practicing and make an assumption about that as to their experience when it comes to the criminal justice system.
Now, Carm didn't let me finish because I was going to say that just tells you pretty much how old the person is. What you want to do is you want to go to calbar.org and look that person up. And when you look them up, that's when you're going to get information about my office, where I'm at, any discipline, any actions against me. And that's when you're going to see the type of job that I may be in now. It won't give you a full resume, but it gives you a little something to work with, and go on their website then next, and check them out. Google them if you have to, which you probably should, just to see what they're involved in and things like that. Do they have the same sort of principles that you do?
And don't be afraid to ask, how long have you been practicing criminal law? There's nothing wrong with a potential client asking that question when they're trying to determine what attorney they want to retain for representation.
You do it for concrete laying at your house. You do it for contracting, putting up sheetrock and stuff. You know.
For any other thing you want to, if somebody is, a teacher, you want to know, how long have you been teaching? What grades have you been teaching? What subjects have you been teaching?
Have you been disciplined?
Yes. Don't be afraid to ask those questions.
Yeah. And we're all holding licenses. And so when we talk about this bar number, really, that's just your license. That is what gives me the right to act as a lawyer. And the same way for teachers, the same way for contractors, right? They got to have their license. And so if a lawyer tells you they are not licensed, I would run to calbar.org and find out why. And if they say that, they better not try to represent you, or else they're practicing law without a license. So
and that's illegal.
Exactly. It'd be a crime. So look at calbar.org. It's an easy attorney search, easy to find. In fact, you can put in the first name or last name, and it'll pull up all the records and stuff, and you have to weed through, and you can tell by their location. So if there were 3 Keith Statons, then you'd look for the one in Sacramento, and that would probably be me. So, but that's how you look up your lawyer. One way of looking up your lawyer, just to know they got a valid license and whether there's been discipline actions against them. And you want to explain what discipline actions are, Carm, and stuff?
They are where allegations have been made of misconduct. That misconduct may not arise to the level of a crime. It may just be ethical misconduct. And so when that happens, a client can complain to the California State Bar. The State Bar will create a case file and begin an investigation to determine whether or not there was any ethically wrongdoing that occurred.
But do they investigate these things, Carm?
Yes, actually, when they open up a case, they do actually have investigators. And one of the first things that they do is they contact the attorney to get a response from the attorney about the allegations that are made. They may require that the attorney turn over a copy of the file or a copy of the fee agreement. And so there is an investigation that occurs. They may also contact, if there are other people that have information that they deem may be relevant to making this determination. And then they determine whether or not there has been a violation of your ethical duties.
Well, wait. Now, if I'm a lawyer, don't I get an opportunity to be heard? Aren't I innocent till proven guilty? It sounds like they can just ask for all your records, and you gotta give them up. You have nothing to say.
No, because one of the first things that they do is they, I believe, ask the attorney to give a response to whatever the allegations are that are being made.
What if I want to take the fifth?
Well, it's not. It depends. Is there an allegation that there has been a crime committed?
Well, if I stole your money, that's not criminal.
I suppose it depends on how that would have occurred. So, of course, attorneys can be involved in criminal activity as well, but usually it's more of a dispute about finances. Oh, I paid this attorney, $10,000, and I don't believe that they did $10,000 worth of work. So those are a lot of the types of complaints that they get, but there are other complaints that they receive as well.
Like you didn't do your job.
The attorney can be represented by an attorney, and usually that attorney is going to want to find an attorney who specializes in handling state bar complaints.
Now, what if they say you didn't do your job? I told you to do your job. You didn't show up at court and stuff. You had somebody come in for you, and you never talked to me. You never visited my client. Those kinds of things. What kind of complaints are those, and are those valid?
Those still can be ethical violations. You have a duty to your client to represent them professionally. And if you fail to do that, in terms of, because an attorney is going to need to visit the client in order to get the client's version of what occurred, or even if the client isn't giving the attorney a version of what occurred, because sometimes they don't, the attorney still has a duty to explain the entire process and the defendant's constitutional rights to them, as well as the risk of what they're facing, minimum and maximum punishment. And so that way, the client, when proceeding in the criminal case, is making an informed decision about whether or not to proceed to trial, whether or not to reject an offer.
Yeah.
What witnesses the attorney may need to call in their trial.
So what if so that would be in a police report and other supplemental reports and things, correct?
What would be in a police report?
All of this information about your case.
Would it be in information will be in the police report, but the police report is not the only place that you can go for information. A lot of times the attorney can get information from the client, and it may be something that the client doesn't even realize is important, but the attorney recognizes the importance that it will have to that person's case. Now,
what if I disagree, though?
Say again?
What if I disagree and I don't want you to do this, lawyer? I don't want you to go find that evidence or something, Don't talk to that person. What should the lawyer do?
The attorney decides strategy, but in consultation with the client. The final decision of how to present evidence at the trial lies in the hands of the attorney.
And that's where I hear people complaining all the time, though, that, well, my attorney didn't do what I want. Is that what they're saying? Because they want to go a certain direction and the lawyer wants to go another?
I actually would not know. Because each complaint that someone makes would be on its own basis. So someone may be complaining specifically that, I wanted my attorney to do this, but my attorney didn't do it. But as long as what the attorney did was within the ethics of what a defense attorney in that situation could do, it's not a violation to not proceed exactly the way the client wants it to go. Again, because the attorney has a specialized knowledge that the client does not have. I will say that I've had occasions where I recall one case where I needed a character witness for the client, and there was a teacher that he had done a lot of volunteer work for. She was never his teacher, but someone who knew him as a volunteer. And the client was so very concerned with inconveniencing her and her having to take any time away from work that he just didn't want to have me call her as a witness. And we disagreed on that at point, but I did explain to him the importance in that particular case of having someone who could speak to his character, who was not a relative, and who had no reason to be biased on his behalf. And it actually worked out very well. I called her, even though he did not want me to call her because worried about the inconvenience to her, but it really worked in that client's favor.
So sometimes,
client does for sure get to determine, and it does not matter what the attorney wants, and that is whether or not to testify. That is a right that is personal to the client. Now, the client and the attorney should thoroughly discuss whether or not the client should testify and the pros and cons of testifying and not testifying. And sometimes there are reasons that a person shouldn't testify that don't mean that the person is lying about their version of what happened, but for whatever reason, they're just not a good witness. They may have a stutter, right? There's some people who have nervous tics or, who laugh when they're nervous. So there are all sorts of things to be considered. But in making that decision, there should be many meetings between the attorney and the client and a full discussion of what their testimony is going to look like, what it's going to consist of, what questions they may possibly be asked, not only on direct by their own attorney, but on cross-examination by the prosecution. And now I will say that we kind of, I want to move it just back a little bit because we've been talking about attorneys that that the client hires themselves, what people commonly refer to as street attorneys or private attorneys.
Paid attorneys.
But there are paid attorneys, but there are a lot of people who are assigned an attorney and they didn't get to choose. They didn't have the funds to hire someone, and so they're randomly assigned an attorney, and that could be a public defender, or in Sacramento County it could be a conflict criminal defender. Keith, do you want to explain the difference between those two?
Yes, I do. And well, I also wanted to talk a little bit about this, before we went on, about this ethical duty to represent your client. What they say is that we have a duty to vigorously represent our client or zealously represent our client, meaning, it's not a ho-hum job and stuff. We're to do everything necessary that we can to assist in the representation of our clients. And they're depending on our expertise and our experience in order to make a decision. Your client is the one who has to make a decision on whether to testify or not. And the way that I deal with that now is you want to talk about that right up front of whether or not they should testify. And the way you do it is, hey, look, the way I think right now, you probably should testify, but I'm not making that decision now. We don't have to decide right now. But right now I'm thinking maybe we should do that. So I want you to start gearing up, practicing being able to tell your story. If you did have a stutter or something that a nervous tic or something like that, your language is not so good, so to speak, or not well, as they say, right? And you're going to be using a lot of slang and things like that. You might want to try to learn to explain yourself in different ways. That's all. The decision to testify. Now, that is one where I think you can see some abuse in that the lawyers don't want the person to testify. And a lot of times the clients are nervous about it and they don't want to get up. So it's very easy, to say, no, I don't want to testify. However, your client probably should testify. And that's the most telling case is cases of self-defense. If you're alleging self-defense, and you don't testify, then there better be so much information on the record, meaning other individuals testify, other information has come in as evidence that there was self-defense used here. All of that better be presented before you ask your client not to testify. And one of the reasons why the judge usually will take your client aside, and they would ask them that question. No matter what your lawyer has told you, do you want to testify? And sometimes the clients probably should. And you may be afraid of a criminal record or something like that. But I've learned over the years, jurors may hear about criminal records and things like that. But if you get up there and you're talking about the facts of your case, then the criminal record becomes secondary to them in determining the facts of the case. And so they may not like it that you have a criminal record, but you get a chance to explain it to the jury when you're on the stand. And that's the first thing you would do is you put your client up and say, what happened in 91? What happened in 87? What happened in these years? And they'll tell you, hey, I picked up a crime here. I picked up a crime here. And you would ask them, did you plead guilty? Yeah, I pled guilty. Because that is powerful when you ask the client, well, how come you didn't plead guilty now? Because I didn't do it, you see? So it looks like a person who would take responsibility for what they did. And on this one occasion, they didn't do it. And so they're going to get up and tell you about their whole history just to let you know, hey, I didn't do it. And that's the difference here. A lot of lawyers, they interpret the power of your client testifying. And in self-defense cases are cases where it's an affirmative defense that must be shown, meaning the defense must bring evidence for the judge to even give the jury the instruction to make a decision. Your client really has to lean towards testifying than not. Because if they don't get that information on the record, the court could say, well, I have no evidence of self-defense. It would have all come from your client. Your client didn't testify, so you don't get to argue self-defense. Actually precluding the argument of self-defense or defense of others. So that's all I wanted to chime in on that issue. So moving on to what you were saying, Carm. Now, what we were talking about. What were we talking about? Yeah. What were we moving on to? Oh, you're muted. Yeah.
Sorry, that was accident. It was accidental. So I would say this regarding and maybe we'll do a show on to testify or not to testify.
Yeah.
Because I am going to say that jurors can hold that person's record against them.
They can.
And I think that can happen more often when that person is a person of color. But we'll save that for another show.
Yeah.
So you were going to tell us the difference between a public defender
Yes.
and the conflict criminal defense attorney.
Okay. First of all, they both are lawyers. Okay. So when you hear a lot of times people believe that the public defender, they're not lawyers. And actually people believe that they're not lawyers. But they are. They are lawyers. They've passed the bar just like all of us. They have experience levels just like all of us. The difference, they work in an office, and that is an office of lawyers, and they all are public defenders, meaning they will work for the counties, and the county would pay them in order to represent individuals who cannot represent themselves. or should not represent themselves, or just need a lawyer for advice to represent them. The public defenders are usually in court to where they can accept the case right away from the time of arraignment, and you become part of their office in a lot of ways. You're a client of their office. So that office is ran by what would be chiefs, bureau chiefs, second, thirds in command. It is a legitimate office filled with lawyers. The lawyers will do various things. Some are doing trials. Some are doing what's called intake. They're just hanging out in the departments. Most are doing trials, hopefully, but some are doing administrative stuff. Some are prosecuting special teams like sex, homicide, burglary, environmental.
I don't know if they would like you characterizing it as hanging out in the department. That seems
hanging out.
Fairly, yeah. You said there are some that are hanging out in the department. I think you're referencing what are
home court
referred to as the SCR deputy.
Our home court, that's their home court. SCR meaning Superior Court Review, which I don't know what the hell that means, really.
It's the courts where negotiation occurs prior to cases being set for preliminary hearing in Sacramento County. There are other counties that right at the arraignment, they immediately force the defendant to set
enter a plea.
Hearing day.
Yeah, enter a plea at least. Yeah.
Yes.
So, but public defenders hang out in the court because they have to be there in order to collect these cases as they come through. And there's no real limit on what they collect, but sometimes they can have more cases than their lawyers can handle. And if that happens, then a process occurs that allows individuals who are on the indigent defense panel to now take cases. And so those lawyers, now think of it this, public defender's office has a bunch of lawyers. Those lawyers are employees of the county. So they are literally county employees. So they get paid on the same scale that county employees get paid on. They get the benefits county employees get. They get the office space and things like that because they are a literal law office. Now, private lawyers who decide to work for the county in accepting cases, that's what the indigent defense panel is. It is a group of private lawyers who are qualified as lawyers to represent individuals at different levels of cases. For example, brand new lawyers would usually start off at a level 1 doing misdemeanors. Lawyers with maybe 2 years experience, around 3 years, or will start doing felonies. Others will start doing strike type cases, serious cases, until you're a 4, where you can do homicides, and 5 and 6, you can do death cases and homicides and anything as serious as that.
Now, let me just be clear. The classification on the panel does not necessarily always correlate with the experience that a person has. So you can have someone on the panel who is thoroughly experienced enough to handle the more serious cases, the murder cases, but who does not, is not at the panel level for those cases,
right?
But may take those cases privately.
Excuse me. If you're a private counsel, you can be a lawyer one day and you can take a murder case. I mean, look at My Cousin Vinny, right? The movie. That's a perfect example.
You can, but you shouldn't.
Well, you shouldn't, because you probably would not be as experienced as someone else, and it would be ineffective for you to assist someone. So if you were to do it, you should associate with somebody like myself or Carmen, and get us to sit or take the case, and they sit what's called second chair, or you got 2 lawyers on a case because they're young and they need the experience. And a lot of times people don't want to throw their money at lawyers who are not experienced. But these are the private cases. What I'm talking about now are private lawyers who work as independent contractors for the county. So we're not the employees, but we will accept cases at a rate that the county negotiates with us. So it could be, and the reason this happens is because of number one, overflow, meaning the public defender's office is not taking any more cases. They have too many. So we call it an overflow period where the next cases that are assigned get to the county until the public defender's case levels level off. There are individuals whereby there's a conflict of interest that appears between the defendants. If it's two defendants charged, they should have their own separate lawyer unless they waive the conflict of interest between the two. If there's 5 defendants, each one deserves their own lawyer. And the way IDP lawyers, the private lawyers from the county, the way it would work is, let's say I have a homicide case and I have 4 defendants. At the arraignment, the public defender would be there and they would decide which one they grab. Now, you got to realize the public defender's office has been here for how many years? So they pretty much represented a lot of people. So, but they decide right off which one of them they can take because there's no conflict, okay? Now, with the other 4, if they say they need lawyers, that's when the indigent defense panel comes in and 4 independent lawyers would be appointed. Not that moment in court, but they will be appointed and the court would notify what's called the panel or CCD, Conflict Criminal Defense Panel. And they would then get notification that we need lawyers on these 3 cases. Then the person who runs that would then, their job would be to find 3 lawyers to represent people in that case. And if it's a homicide case, then it would only be lawyers who are qualified at the level of 4, which is just a level number. That means that you've got so much experience that we allow you to do homicide cases. So they would have to pick 3 lawyers from that level to represent the other 3 defendants, unless they hired their own private counsel, in which case they would not get an appointed lawyer. So when you...
Or the appointed lawyer, if the lawyer had been appointed, let's say the Conflict Criminal Defense Panel had been appointed, once they've hired their own attorney, either they or that attorney should notify whatever attorney has been appointed by the panel. And the attorneys that the Conflict Criminal Defender Panel assigns the cases to are already on a list. So it's not as if they're calling up the independent attorney saying, hey, can you just come in and take this case? They've already been vetted. They've already are on a list of attorneys who
at levels.
Conflict Criminal Defenders Panel can assign cases to. And I shouldn't actually say assign because they don't actually assign them. What they do is they contact the attorneys and ask the attorney if the attorney can actually take that case, if the attorney has room in their caseload. And it is the attorney's individual decision as to whether or not they will take a case or not. Whereas with the public defender, when their office accepts a case, whoever the supervisor assigns that case to, they have to, handle that case. They don't get to choose and say, hey, wait, I'm a little busy. I don't want to take this case.
Right. And realize, look, the people at the panel that we're talking about, they have 3 other lawyers who are qualified at level 4 to be able to take it. And they will ask you, can you do it? And you've got to respond within a brief period of time that you can or cannot. And they'll give you the facts of the case, may give you discovery, the police reports, and then you're on your own with that defendant. You don't have to report back to the panel what's happening in your case. You would ask the panel for money in order to help you prosecute. It has the panel not prosecute, but to help you investigate. And you would ask for investigators to be appointed to help you investigate that case. And that would come from the county. Now, the IDP lawyers when I say are independent contractors, meaning they take cases privately too. So they probably have caseloads that mixed between ones taken from the panel, from the county, and ones that are paid lawyers. And that's okay, you see. Um, and you, as a IDP lawyer, you're going to be required to take that case from the beginning to the end, all the way through trial. Public defender's office may not work that way. They may have individuals who only do certain misdemeanor trials, individuals that only do preliminary hearings. They may shift teams.
So I was just going to say, if they're assigned a public defender, it is not uncommon that they may have one person who represents them for the arraignment and the initial negotiations.
Yep.
And then for preliminary hearing, the case may actually be assigned to a new attorney. It is extremely important to maintain that attorney-client connection, even if your attorney, you have the public defender and your attorney changes.
Right.
You still need to establish a relationship now with the new attorney who's going to be representing you. And yes, most times they will have the notes from the prior attorney. They should have them. They should be in the file. But sometimes, everybody writes things differently. So they may ask to hear your story or your version or about witnesses that you know about again. You shouldn't be offended by that. It could just be for clarity's sake.
And your lawyer, if you've had the public defender and it's not a homicide or a sex case, you're probably going to have 2 or 3 lawyers through the life of your case. You don't get to pick which ones you have, which it's so important to maintain contact with them. Always get their number, always get their full name, because if it switches, you can call in and say, who was my lawyer? Here's my case number. Who's my lawyer? Give me their phone number. And they'll do that at the head of the public defender's office. You call their line and that'll happen. But you cannot control which lawyer you get.
If the lawyer is one of the public defenders,
right,
or even
or the panel,
or a private attorney,
right?
Because there are people, and I know you've had this happen, lawman, who will call up and they specifically, I want Mr. Staten to be assigned to my case.
Yeah,
and it's the luck of the draw if they were to happen to get him. You
Correct.
Can't call in and demand. The only way you can determine who your lawyer is going to be is if you are hiring that person yourself.
Yes. And so that's why one of the big rules that you've got to have to maintain a good relationship with your lawyer is to contact them. If they contact you, you get right back at them. You say, just even if it's late night and you know they're not in the office, that's not an excuse. They got an answering machine. Call them up and tell them who you are, that you're calling back. Most criminal lawyers, good ones are working through the night. Sometimes they're working late in their office. They might pick up the phone at 9, 10 o'clock and you're like, you're there. I was expecting to leave a message in there. And I know I'm in trial. I got to work. So a lot of the key thing to know, they're lawyers. The second thing, stay in contact with them. Make sure you have the right phone numbers for them and their names. And the third thing is you have to work with them.
Don't be afraid. I think you were just about to say this. Don't be afraid to ask questions.
Right.
No, I can't remember who said it, but there was someone who said the only stupid question is an unasked question, right? There is no harm in asking for clarification if there's something that they said that you don't understand.
And that might be a lot of things.
Yes.
That you don't understand. If I start talking about jury instructions and cal crims and I don't explain what I'm talking about, you don't know what I mean.
Because sometimes as attorneys, we may forget and we're speaking in a lingo that we are familiar with,
right,
not realizing that the clients may not be familiar with it.
Right. Like they may offer you a bullet. They're offering you a bullet. What does that mean?
and that means they're offering you a year. But if you've never had any involvement with the criminal justice system, you've never heard that term before, you're like, why are they offering me a bullet? Or they threaten, they're going to kill me? What do you mean they're offering me a bullet?
What does that mean?
So as attorneys, we have to remember when speaking with clients to if we use that lingo, to make sure that we explain it in detail to the client. And if your attorney doesn't, don't be afraid to ask,
what's a bullet? Right. And it gets deeper, okay? I would do this. Look, the penal code sections that you're being charged with, you want to copy them. You can get online and get a copy of the penal code sections. You can also get a copy of the jury instructions, but you may not know which number it is. But that'll be a perfect question for your lawyer. I'm charged with 3 counts. I want the jury instruction as to those 3 counts. Why? You want to tell them?
That is what has to be, the elements that are contained within there are what has to be proven beyond a reasonable doubt in order for there to be a conviction. And if any of those elements are missing or can't be proven, then that case should not stand.
You are entitled to an acquittal. So, and I mean, if there's 5 elements that need to be shown, each one must be proven beyond a reasonable doubt. And
so
if there's
they have 4 of them, but they don't have that 5th one, they don't. That jury should be voting not guilty.
Right. And I'm going to tell you something. Look, lawyers don't understand jury instructions sometimes. Okay. It takes a while to really understand their value. That's why I put them first. You go to a jury instruction first because it lays out exactly what must be proven. And it talks about lesser related offenses. Other charges that could come from one big charge. You can't get me for attempted murder, but you might can get me for this little assault with a deadly weapon. See? So, you want to look at those things because, number one, you want to see the elements because you might be providing the facts and you can say, well, they can't prove that, and here's why. And then that's what your lawyer wants to hear. That's engaging with your lawyer. And then part of it is just being bold enough to say, give me some jury instructions.
And again, not just give them to you, but discuss them with you. Take the time to make sure that you have a thorough understanding. Again, if you went to your doctor and your doctor told you that you had cancer and just walked out of the room, would that be satisfactory? No, because he didn't tell you what kind of cancer. He didn't discuss with you the possible potential treatments for the cancer. He didn't discuss with you whether or not it was terminal or not.
Right.
All of those are things that a person is going to want to know if they've just received that diagnosis. The criminal justice system and criminal charges are kind of that same way. Yep. If I just told you that you're facing a murder charge, you're going to want to know, well, what does that carry? Are there any lesser crimes? What if the victim was the one who initiated the violence? Right. And so those are the discussions that we want to encourage people to have with the attorneys that are going to be representing them. You may not initially even like the person that you've been assigned to. But again, this isn't a friendship contest.
Right.
You don't have to like them, but you do have to work together to try and get the best outcome possible for you under your specific fact situation.
And let me talk frankly here. Look, you can get, and as a Black person, you can get a white lawyer, and that white lawyer looks like a cop. Or that white lawyer looks like she doesn't care about me. She doesn't even know me. You see? She lives in the hills and she's lived a privileged life and she does this work with the poor. This is her penance or something. You can have all kinds of judgment about that lawyer, but you got to let him go in order to get the information you need. Don't let that stop and make you go, I don't want to meet with that lawyer no more. I'm not going back and seeing them and saying things like that and doing things like that. It stops you from asking questions, from listening to what they're saying. Things like that. Don't let it quit you on that. Come on. Looks can be deceiving too. But you're not there, like she said, to say, "Oh, we both pretty. Oh, you do think like you listen to the same music as me." I don't give a shit. I mean, you listening to the same music. How about we all on the same page in terms of the facts and the law here? That's what you want to be listening to, is the music they're playing in that regard. So you have to be assertive. You have to be aggressive sometimes, not fight aggressive, but just, hey, I would like to know this. Hey, I need my police report, because you have a right to your police report and all other documents. You got a right to watch every video, listen to every 911 call, every recording of a person's interview, because that'll be different than what's on paper. So you must demand these things, though, from your lawyer, because I'll tell you this, the lawyer, if it's me, I got to pay for it, or the county's got to pay for it. So it belongs to you. Believe it or not, your file and your documents belong to you first, not the lawyer. So don't ever believe a lawyer saying, I can't give you something. They can give it to you. They just have to redact it to put it in a form so that they don't expose witnesses' names, addresses, phone numbers, victims' names, addresses, phone numbers, and identifying information.
Not names. Let's clarify.
I'm sorry, not
They're
names.
entitled to names. They're just not entitled to
Addresses, phone numbers.
I just saw a report that someone had redacted, and they had taken out all of the names of all of the witnesses, of all of the suspects. You read the report, it wouldn't be helpful to someone because you couldn't tell who they were saying did what.
Yeah. And young lawyer, or just a lawyer that doesn't understand the rules. That's all.
Yeah. Well, once again, lawman, we are nearing the end of another Friday night session.
Oh, we got plenty of time, Carm. We got 4 minutes. Come on.
3 minutes by my clock, and I know that sometimes you like to impart a piece of
knowledge,
special knowledge to our viewers, and so.
All right, I shall do so. Okay, this week on the 20th, I gave another lecture for the Men's Empowerment Group at Sac State. It's a Know Your Rights seminar. I now have cards that are laminated that sit like a tent. They also can fit like a credit card in your wallet. They can fit up on whatever you call that thing, the shade up on the top or something. And if you ever encounter police officers, you only need this card. It's laminated so that it doesn't what do you say? Rain, snow, sleet will not you won't damage this card. Now,
we have a comment that says, does the card make me bulletproof? I'm going to let you speak to that.
Yes, it does allow you to exercise your rights that are necessary when you encounter an officer. And this is how it works. You got this card. You get pulled over. You're nervous. You're upset. Whatever it is. But you got the card. Let the card speak for you. Cop's going to come at some point and talk to you. Oh, I'm supposed to say, am I free to leave, cop? And if the answer is no, then I'm detained. And for safety reasons, start filming. Let's see. Give your name. Present your ID card, because that's all you have to do when you are detained. Say, I want to speak with a lawyer, or I need a lawyer present now. This is the only way to stop questioning. Shut the hell up. Don't run. Don't resist. Take names and badges of the officers. And that's what you do. If you ever forgot that that's what you should do, you have this card in your car. You have it in your wallet. You have it on the dash. You have it somewhere where, and you follow the protocol. So you can get them from me. You can call, ask. I'm trying to distribute them.
I was just going to say next. Tell the people where they can get these cards, lawman.
They can get them from me, but I am trying to get them out to organizations like NAACP, Urban League, all of the barbershops, beauty shops, liquor stores, places, Robinson Center, just places where us come and go, to where the place could even say, hey, why don't you take one of these things with you? Because if you encounter.
Get them from you, just because right now they may not be in all of those places. Are you going to give them a specific location where they could stop by?
Yeah, they probably, I mean, the easiest way is to drop by the office and Danielle will give you one. And that's at 10.
You want to give them the office address?
No, I'm going to make them guess and get on the line and figure it out. They know my name. 1023 H Street. 1023 H Street, Suite A. Blue building with my name on it. So you come by, knock on it. Hey, we'll let you in. We got to keep the door locked because anybody runs in. And then just ask Danielle, hey, let me get one of the cards or a couple of them. Maybe you might want 20 or 30 because you're going to go back to your barbershop or your office or something like that. Okay. So they're free. Take one. It'll explain to you how to exercise your rights. And then after exercising your rights, what you should do. Shut up, be quiet, don't fight, let it ride. And you will contact your lawyer later and they'll do the fighting for you. So that's what I'll say this week, except that, we're truly blessed to still be alive and still be pumping and doing the things that we have to do. We have to watch out in our conducts and behaviors and not get suckered into being unsafe and into situations to where we're hurting our own kind. Okay. So now's the time to be very diligent about things, making sure that each other have food, clothing, and helping each other out. It shouldn't just be done during Christmas season.
Yes.
Which I hate that part.
So true. So true. So true.
So Carmen, any words of wisdom?
No, I think we are done for the night. We would again thank you for spending your evening with Courtside.
With Lawman.
And Carmen B.
All right. We are gone now. Take care, everybody. Be safe. And we'll see you next week.
Have a good evening.